the Oversight Committee exists to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to secure these rights and to protect American tax dollars. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It's our job to work tirelessly in partnership with citizen watchdogs to protect these rights and to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. In recent years, we've seen a massive expansion of government and its growth in spending. That is a given as our economy has grown, but there's a culture that's been created that feels it's entitled to taxpayer dollars. The entitlement philosophy has grown both in the area of contracts but in grants. Today, among other things, we will examine the growth in grants. Grants are a circumvention of both competitive bidding and specific appropriation by Congress. Today, when we talk about suspensions and debarment, what we're really talking about is a common-sense process that does what the American people already expect government to do: ensure that the vendors we use, whether for grants or contracts, in fact meet the expectation of the law, and when they don't use them again. We need to have a culture of zero tolerance for fraud, for criminals, for tax cheats. For those receiving taxpayer money through grants and contracts, we must have a standard that meets the expectation of the American people. When I was a small child, and all my life growing up, we've heard the expression, "Fool me once, shame on you." And we all know that "fool me twice, shame on me." One of the problems in suspension and debarment is, in fact, that the system does not prevent "fool me twice." In some cases, "fool me twice" occurs within the same agency. In some cases, it occurs within different agencies who do not communicate about bad actors. I wish I could say that this is the first debarment hearing that's been held by this committee, but this is, at least biannually, a hearing that we come back to again and again because the problem isn't fixed. Several months ago, I publicly put forward draft legislation for a comprehensive suspension and debarment reform bill entitled Stop Unworthy Spending Act, or Suspend Act. It has been posted on the committee's website since February, and I believe it is becoming time to move it forward, especially when we look at specific events that have led to us having less faith in our government. We need to restore that faith. Year after year, Washington takes more money and Americans have seemingly less to show for it. Time and time again, we see contracts being reissued when failure has been the previous result. So on this issue, one that I am proud to say has been bipartisan, has been in fact one where we on this dais know there's a problem. Administration after administration has said, give us a little more time and we will fix it. I believe that the time to believe that it will be fixed without legislation has expired. Today's hearing is to probe into any final details before this committee seeks to move comprehensive legislation to ensure suspension and debarment is reformed. With that, I recognize the ranking member for his opening statement.
Thank you very much, Mr. Chairman. This is indeed a bipartisan issue. As I was sitting here, I could not help but think about the neighborhood that I live in and that I left a few hours ago, where we've got young men who make one mistake, get a record, and then punished for the rest of their life. Jobs they can't get, opportunities they cannot take advantage of. And I'm sure when they hear about big companies doing things wrong and then finding themselves right back doing business with the government, they ask the question, where is the justice? Or is it just us? And so, Mr. Chairman, I thank you for calling this important hearing. Today we will examine how the government is using suspension and debarment in federal spending to protect taxpayers from potential waste, fraud, and abuse. Suspension and debarment are mechanisms by which the federal government protects taxpayers by prohibiting the award of new contracts or grants to individuals and businesses that are bad actors. Debarment is automatic upon conviction of certain crimes, but federal agencies also have the authority to suspend or debar an individual or business in cases where there has not been a conviction or an indictment, but where there is, nevertheless, ample evidence of unethical behavior or incompetence. A report issued by the GAO in 2011 found that some agencies have failed for years to suspend or debar a single individual or business. For example, GAO found that FEMA had no suspensions or debarments from 2006 to 2010, despite the fact that congressional committees found numerous instances of contract waste, fraud, abuse, and poor performance in the aftermath of Hurricane Katrina. What's wrong with that picture? In another example, the Department of Justice suspended or debarred only 8 contractors from 2006 to 2010. Making matters worse, a 2011 Inspector General's audit found that from 2005 to 2010, the Department issued 77 contracts and contract modifications to some of the same entities that the Department suspended or debarred. Something is absolutely wrong with that picture. Although a 2012 report by the Interagency Suspension and Debarment Committee noted that marginal improvements have been made since the release of the GAO report in 2011, it also stated that persistent weaknesses remain throughout various agencies. The vast majority of individuals and businesses who participate in the federal marketplace are honest and do their utmost to fulfill the terms of their federal contracts. It is not ethical or fair when these competent government contractors lose government business to those who have performed ineffectively, inefficiently, and dishonestly. Our goal is not to punish contractors, but to protect taxpayers. Taxpayers deserve to know that the federal contracts and grants are not awarded to those who have acted dishonestly, irresponsibly, or incompetently. Having powerful suspension and debarment tools does little good if they are not being used effectively. The GAO report found that the civilian agencies with the highest numbers of suspensions and debarments share certain characteristics. First, they dedicate full-time staff to suspension and debarment process. Second, they have detailed guidance in place. And finally, they have a robust case referral process. I think we need to carefully examine these best practices. The draft Suspend Act that the Chairman is sponsoring seems, and I think that it's something that we should be able to do in a bipartisan way. It is an effort to shed light and make this whole debarment process much more efficient, transparent, and make it accountable, and make sure that those who are suspended and debarred are effectively dealt with. I look forward to working with the Chairman to further improve this legislation. As our nation's economic recovery continues, it is important that we guard against unnecessary spending and make sure that we are doing every single thing in our power to protect taxpayer funds. I look forward to the testimony of our witnesses today, and with that I yield back.
I thank the gentleman. Members may have 7 days to submit opening statements and other extraneous material for the record. We now welcome our witnesses. Mr. John Newman is Acting Director of Acquisitions and Sourcing Management at the Government Accountability Office. Welcome. The Honorable Angela Stiles is a partner at Crowell and Morning's Washington, D.C. office, and, of course, the former wait a second. Thank you. I know. Just next page. Federal Procurement Policy in the Office of Management and Budget. And see, I would have said administrator, and we wouldn't have agreed. And Mr. Scott Army is the General Counsel at the Project on Government Oversight. Welcome all. Pursuant to the rules of the committee, and this is all on one page, would you please rise, raise your right hands to take the oath. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect that all witnesses answered in the affirmative. Please be seated. Now, I'm pleased to say you're all pretty experienced at this. So, your entire opening statements will be placed in the record. We'd like you to stay as close as you can to 5 minutes or less to leave plenty of time for questions, because ultimately we'll read your opening statements, or in most cases have, but we certainly would like to be able to get your insight to specific questions. Mr. Newman.
Thank you. Chairman Issa, Ranking Member Cummings, and members of the committee, I'm pleased to be here today to discuss the Federal Government's use of suspensions and debarments. In 2012 alone, the Federal Government spent more than $517 billion on contracted goods and services. And as you know, to protect the Government's interests, Federal agencies are required to award contracts only to responsible contractors, those with a satisfactory record of integrity and business ethics and capable of performing required work. One way to protect the Government's interest is through the use of suspensions and debarments to exclude firms or individuals from receiving contracts when they engage in misconduct. My statement today highlights two key points. First, agencies we reviewed with the most suspension and debarment activity shared certain characteristics. And secondly, Federal Government efforts to oversee and coordinate the use of suspensions and debarments faced challenges. Let me expand a little bit on my first point. In 2011, when we looked at 10 different agencies, we found that the 4 agencies with the most suspension and debarment activity shared 3 characteristics. They each had dedicated program and dedicated staff, detailed policies and procedures, and practices that encourage an active referral process. The first of these characteristics was the dedicated program and staff. This is needed to carry out the essential functions of an agency's program. Each of the four agencies we reviewed with active programs had dedicated staff that were focused on reviewing cases of contractor misconduct and poor performance for possible suspension and debarment. Secondly, these agencies had detailed policies and procedures that went well beyond the guidance in the Federal Acquisition Regulation. And lastly, we found that those agencies with active programs each had practices to encourage referrals of contractor misconduct to be considered for appropriate action. This referral process required senior agency officials to promote a culture of acquisition integrity so that suspension and debarment is understood and utilized by all staff. The remaining 6 agencies we looked at in 2011 lacked these characteristics and had few or no suspensions or debarments of Federal contractors, despite having billions of dollars in contract spending. The second point that I'd like to highlight is on Federal Government efforts to oversee and coordinate the use of suspensions and debarments. At the time of our review in 2011, the Interagency Suspension and Debarment Committee faced a number of challenges. This committee, as you know, is charged with monitoring and coordinating the suspension and debarment system across the Federal Government. However, it relied on voluntary participation and an informal coordination process that not all agencies participated in. We noted that agencies without active suspension and debarment programs generally were not represented at the committee's monthly coordination meetings. In response to our recommendation, OMB issued guidance that directed Federal agencies to appoint a senior official to ensure regular agency participation in the interagency committee meetings, among other actions. and since then, several agencies have taken steps to address our findings and recommendations. Chairman Issa, Ranking Member Cummings, and members of the committee, this concludes my prepared statement. I'm pleased to respond to any questions that you may have.
Well, thank you, and we'll withhold questions until we've heard from all of the witnesses. Let's recognize now Angela Stiles, partner in Crowell and Mooring. Welcome, and you're recognized.
Thank you very much. Congressman Micah. Thank you. Thank you very much. Congressman Micah, Congressman Cummings, and members of the committee, it's an honor to be invited to testify here today. There is little question that changes to the suspension and debarment system are needed, and I commend the committee for taking a hard bipartisan look. Federal suspension and debarment officials exercise a powerful and highly discretionary authority that directly affects the credibility of our entire procurement system. It has to be fair, and it has to be transparent. The dialogue created by your draft legislation has already created greater attentiveness to fair process, consistency, and timeliness. Because a significant portion of my legal practice involves the representation of companies and individuals in suspension and debarment proceedings before many Federal agencies, both civilian and defense, I have a unique perspective on the multitude of processes, procedures, standards of review, and remedies, both written and, I think, very important to the committee, unwritten ones as well. While the Federal Acquisition Regulation, the FAR, and the non-procurement rules establish a high-level framework, much of the system operates using unwritten practices and tools. While many civilian agencies are bolstering suspension and debarment programs in response to your congressional oversight, it is hard to be confident that the current written processes or the unwritten practices ensure fairness, meaning that all companies and individuals facing debarment are given a similar opportunity to properly present their case, and that the correct result is obtained. It is important, however, to separate the process from the people. We have been extraordinarily fortunate over the years to have dedicated, objective, and fair-minded civil servants running the suspension and debarment processes across the Department of Defense, the General Services Administration, and the Environmental Protection Agency. The creativity and openness of the suspension and debarment officials at these three agencies have for many, many years facilitated fairness and objectivity. For the long term, however, the system cannot be sustained on the fairness and objectivity of individual suspension and debarment officials alone. Across the government, the processes, procedures, standards of review, remedies, and tools must be consistent and transparent. The lack of access and transparency is an impediment for companies that are working to improve ethics and compliance programs. When problems do arise at companies, and they arise even at the most responsible of contractors, the agencies need to be able to work in partnership with contractors towards continual improvements. DOD, EPA, and GSA learned long ago that by having an open door for contractors to discuss compliance and ethics concerns, both parties could agree on expectations and appropriate changes to contractor programs. From my perspective, the greatest concern are the unwritten processes across agencies. They create significant issues of fairness. I have seen this most specifically in 5 areas where the processes vary significantly across agencies and are not transparent to all the parties. I discuss it extensively in my written statement, but this includes show cause letters, requests for information, access to the administrative record, the public release of information, administrative agreements, and lead agency determinations. These 5 different areas are not articulated in the FAR. They are not available to the public to understand how the suspension and debarment process actually works on a day-to-day basis. In conclusion, I think there is little question that changes are needed, and changes can add significantly to consistency among the agencies and transparency. I think making our procurement process better through ensuring that our suspension and debarment process works better, will give taxpayers significantly greater confidence that the government is buying from contractors with the highest ethical standards. And I don't mean contractors that are just meeting the law. We need contractors that understand what value-based procurement programs are, ethics and compliance programs within their companies, and they need to do more than simply meet the requirements of the law. They need to lead our U.S. companies in what it means to be a responsible company. That concludes my prepared responses, and I'm happy to answer any questions you may have.
Thank you, and we'll hold questions. We'll now turn to the next and last witness, Scott Amy, and he is General Counsel, Project and Government Oversight. Welcome, and you're recognized.
Thank you. Congressman Mica, Ranking Member Cummings, and members of the committee. Thank you for inviting me to testify today about the state of the Federal Government suspension debarment system. From exposing outrageously priced spare parts to initiating the creation of the FAPA system, which was born out of this committee, POGO has promoted a good government agenda. Today's hearing and improved attempts to prevent the government from doing business with risky contractors, contractors with criminal, civil, and administrative misconduct records or poor performance histories, is essential to improving Federal and grant spending that now exceeds $1 trillion annually. Everyone agrees that the Federal Government should not do business with companies that have defrauded the government or violated laws or regulations, performed poorly on contracts, or had their contracts terminated for default or cause. But in reality, the government is awarding contracts and grants to such companies. The government has a two-tier system to protect the public: pre-award responsibility determinations and suspension and debarment. I discussed both in my written testimony, but I will focus today on the failures of the suspension debarment system. The suspension debarment system is a vital tool in protecting agencies, government missions and programs, and taxpayers. Despite a complex framework outlined in the Federal Acquisition Regulations and comprehensive programs within certain agencies, we are still finding flaws in the system. Excluded entities are still receiving new contracts or grants. Companies can be viewed presently responsible by just firing a few employees or promising to enhance training or compliance measures. Many agencies are not effectively using the suspension debarment tools at their disposal, with NRC, Social Security, Commerce, HHS, and Labor having 10 or fewer suspension debarments in the recent years. Inconsistencies are the norm, and we often hear about government reports and audits and media stories alleging criminal activity or poor performance one day and a new multi-million-dollar contract or grant awarded to the same entity within days. Additionally, the length of suspensions can range from anywhere from a few days to years. Referrals of the suspension debarment actions can be slow. I'm still confused of how BP was considered responsible for years after the Gulf oil spill disaster, but was only suspended 2 weeks after it pleaded guilty to numerous criminal counts. BP's suspension has lasted over 6 months, and it will be interesting to see how much longer that it will last, and if it will be waived or lifted prior to a new solicitation for oil or petroleum products or services. This is the perception that the larger contractors are too big to suspend or debar. Since 2000, POGO estimates that there has been approximately 82,000 suspension or debarment actions levied against companies and individuals, but the number of large contractors that have been sanctioned under the system can be counted on two hands. As far as the Suspend Act, earlier this year, Chairman Issa released a discussion draft of a bill entitled the Stop Unworthy Spending, or the Suspend Act. I applaud the Chairman's handling of this draft bill and the outside-the-box thinking that was put into it. We have heard for years that the suspension debarment system is fine, but yet nearly every government reports that there are flaws in the system. Past efforts to reform the system have been calls for mandatory suspension or debarment for certain procurement or tax-related offenses. Those efforts were short-sighted and unrealistic. SDOs need flexibility to review a contractor's present level of responsibility and mandate suspension or debarments only when necessary, and not to just punish a contractor. I agree with the Chairman and the draft language in the bill that the consolidation of suspension and debarment offices and resources will improve consistency and be a better use of the limited resources that are appropriated for suspension and debarment activities. The bill also attempts to expedite review, which is crucial. Section 5 looks to coordinate agency actions. For years, POGO has been concerned with a lack of coordination between IGs and others within the acquisition and oversight world. POGO provides the following recommendations that should be considered as a Suspend Act is being finalized. Mandate that IGs or other investigative units make referrals to SDOs after opening an investigation and making findings that reasonably support a basis for suspension or debarment. SDOs shouldn't have to wait until the Justice Department has closed a file to make a responsibility determination. Require SDOs to make suspension or debarment determinations within a set period of time after receiving a government referral. The determination should include a description of the referral, the SDO's justification for suspending or debarring the entity or not taking action, and any description that is concluded in a settlement or an agreement. The record should be publicly available so that SDOs are held accountable to the public. Enhance annual reporting to Congress of the spending and suspension debarment workforce, the total number of referrals, declinations, fact-based suspensions or debarments, administrative actions, anything that comes from those offices. Clarifies that suspension and debarment activities are inherently governmental functions that must be performed by government employees. Release past performance data. In the past performance data is currently released by GAO and Federal courts in bid protest decision, and the proactive release of such information would benefit government officials, competitors, and the public. Thank you for inviting me to testify. I look forward to working with the committee to further explore how we can strengthen the suspension debarment
Thank
system.
you, and we'll start a quick round of questionings here. Mr. Newman, this looks like we're spending about $1 trillion a year, it looks like, of government money on contracts and also grants. Is it as bad in grants as it is in contracts as far as not compliance with getting rid of the bad players?
Well, certainly.
About $0.5 trillion in each, isn't it? And where is it as bad in contracts as it is in grants? Did you look at both?
In 2011, we did look at the total number of exclusions for both grants and contracts, but our work focused on agency actions taken under the Federal Acquisition Regulation for contracts. But the same practices apply for the non-procurement comment.
So you really didn't look at that aspect as one, just in general. You looked at the failure to comply with getting the bad actors out of the process.
Certainly, we looked at the agency suspension and debarment programs.
Let me ask you this. It looks like we passed law. This is another one of these groundhog attempts by government where we keep going back and trying to clean this up, and nothing's done. Now, there have been attempts in the past and mechanisms put in place to try to make, again, the bad actors be identified and excluded. Is it your belief that only legislation now can remedy this? GSA had some ability to do this. OMB had some ability to take steps.
I think based on our work, there are a number of improvements that agencies can take.
No, do we need a law with teeth in it to make certain that these things get done?
We certainly need agency action
Well, okay, they already have the ability for the agency to act, for agencies to act. It appears, and you were with OMB, Ms. Stiles, OMB directed agencies to appoint senior officials responsible to the agency's suspension and debarment program. Has that taken place in all the agencies? Are you aware, Ms. Stiles or Mr. Newman? Go ahead. Yes,
So I
no,
can only
maybe?
tell you from the outside perspective, not consistently, no. And to the extent that they've been appointed, it's actually very difficult to figure out who they are at certain agencies.
Is that your observation, too?
Yes, that
Okay,
was
so
our observation as well.
They have the ability and can administratively go after some of these things. Then we've got some of these programs. How much money has GSA spent on either the SAM program or EPLS program? Do you know?
We didn't look at that.
You didn't look
the
at
amount of
that?
money that
Okay.
GSA spent.
But they're trying to merge these two. One was to set up a list of bad players, right, and that has not been effective. Who are the worst? I mean, that's the crux of most of the testimony, the purpose we're here for. Now, is responsible for, again, moving forward? Is it GSA and OMB, and neither have done that? Is that correct, Mr. Newman?
Both OMB and GSA have roles in making
Yeah, but
suspension debarment programs more
obviously
effective.
people haven't, I mean, they aren't reporting. Contracts are being given in the hundreds of millions of dollars to bad players. Is that correct?
We do know that there have been some mistakes made in the past where contractors that were debarred were given contracts.
Who's the worst? I saw some, Mr. Cummings mentioned FEMA, you've got HHS and Commerce, lack effective programs. Who's the worst?
But what we found was that there were 6 agencies at that time that had taken few or no suspension or debarment actions and didn't even have policies and procedures in place or dedicated staff.
In spite of, again, the requirement, administrative requirement to report, in spite of the requirement to set up a system to maintain a current list. The list hasn't been current, right? Current or complete?
The GSA has continued to experience problems with that, and GAO has reported on that over the years. We understand that they have taken steps to work with the agencies to improve that, but there are still reports of problems.
And you were at OMB, Stiles. What are they doing at OMB? I mean, that's part of their its Office of Budget and Management, just ignoring, again,
So at this point,
either the requirements to report or keeping a list that would be referred to and people disbarred or suspended, being prohibited from getting these contracts or awards.
So at this point, they issued the 2011 memo, and they have policy responsibility for the EPLS, which is now in the System for Award Management, or SAM. The data is in SAM. It's just not as thorough and complete, and it's difficult to manage. And
final question. You've looked at some of the legislation and commented on it, sir. Does it have enough teeth to get the job done and make these agencies comply?
There may be a few minor tweaks that need to be implemented, but for the most part, I think you're hitting on the problem. Unfortunately, the suspension and debarment system has been around for many years, but it's been through executive order, it's been through some regulations, it's been through kind of the stovepipe mentality that the agencies were required. You won't find anywhere in the U.S. Code other than a note in the financial chapter of the U.S. Code in Section 31 where there's a note on how the ISDC is even supposed to run. So I think that's part of the problem is we created a system, but we didn't supply sufficient guidance on how that system should operate.
Well, again, every one of these hearings are absolutely stunning of the unresponsiveness of agencies and simple things like keeping a list and then debarring or disallowing people who are bad players and ripped off the government. Mr. Cummings.
Mr. Amy, the thing that I'm concerned about is being effective and efficient, period. And, you know, I say that quite often we in Congress have a lot of motion, commotion, emotion, and no results. And at the same time, the public who pays us depends upon us to carry out government in a responsible way are shortchanged. The question becomes, when you look at, based on your research, do you get the impression that there are just some folks that just don't give a damn about whether somebody who is a bad actor continues to have opportunities over and over again? Is it that the policies are not in place? And then I want you to comment on the Chairman's bill. Again, I want you to, if there are any deficiencies in it, again, we want to know. It looks like a very good bill to me. But you get tired of going down the same road over and over again and nothing. When I say nothing, nothing happens. And so what that says to the bad actors is that we can continue to do the stuff that we do and keep coming right back to the government and saying, keep me in business, not for a year or two, but for generations. So help me with this.
Well,
Start with the Suspend Act, because I think that's a good place to start.
Well, I think this Suspend Act has some great qualities to it. I mean, we would support it with a few minor tweaks. I think there's some room for improvement in trying to get referrals in quicker. The biggest thing is the IGs or the oversight community conducts investigations, and they may have met the burden to make a referral over to an SDO to have them start the suspension debarment process. Like, unfortunately, I hate to say it, but in reality, the suspension debarment process is being used as a punishment in its current state, because so many times we have to wait for the Justice Department to close its file and, and get a conviction or some kind of civil action against a company before an SDO takes action. And I don't think we should be doing that. We need to protect the taxpayer. I mean, they are two separate systems. One is accountability and to hold them criminally or civilly accountable, but the other is to protect the American taxpayer. And the BP example is the best that I can think of, where I don't know why 2 weeks after they finally pleaded guilty that they were considered non-responsible. Why, I'm sure the EPA was looking at them, and I know there were some issues with lead agency discussions, and obviously BP is a major supplier of oil and petroleum products and services to the Federal Government. So at that point, the military, the last thing they need, especially from a competition standpoint, is to be down a vendor. However, it just boggles my mind that we had to wait nearly 30 months after the oil disaster before we could hold BP accountable and consider them non-responsible, which now they've been considered non-responsible for the last 6 months. As far as an answer to your overall question is, the FAR does provide a very complex system that should be followed. Do I think people want to provide bad companies with contracts or grants? No. Part of it is laziness. Part of it may be they checked the excluded parties list or the SAM system a month ago and all the vendors checked out, but they didn't check the day that the award was given. So at that point, a contractor may have been suspended or debarred in that time frame. Contractors know how to game the system. Until we end up with a system of unique identifiers and be able to track companies and their owners, that we're going to have a problem, that it's very difficult. So contractors know that, okay, well, we're suspended or debarred, but we'll open up a new entity under my wife's name, my uncle's name, my brother's name. So at that point, there's some gaming of the system. So that's where you kind of have some of the flaws that GAO and some of the IGs and the ISDC have pointed out through the years.
Yeah, Mr. Newman, what's the most common cause for debarment? In other words, what's the maybe you can answer that, Mr. Stiles. I don't know. In other words, what's the most common reasons? 1, 2, 3.
We didn't do analysis on the times, what reasons were used.
Well, why don't you tell me a few? You know some of them, right? That's your job.
I mean, there's certainly, contract fraud, bribery, theft, tax evasion, any other contractor misconduct, or even poor performance were all reasons for suspending or debarring contractors in cases that we've looked at.
So somebody can be debarred for poor performance?
Yes, they can.
And how is that measured, Ms. Stiles? In other words, what's poor performance in one person's mind may not be poor performance in another. And you have a lot of situations where we see contractors that will come in and this is to me, it bothers me tremendously. We saw it in the Coast Guard when I was chairman of the Coast Guard subcommittee. They'll do a bid for one price, and I know that there are change orders. I mean, not change orders, but changes need to be made. But some of them were just ridiculous. I mean, almost a third more for the cost of a ship or whatever, and you begin to wonder about some of those things. Is that the kind of stuff? I mean, talk to me, Ms. Jamie.
Well, I don't think that's probably enough to get you suspended or debarred, but it is a possibility, especially if that type of information is captured in the FAPA system. then at that point, at least it raises red flags for contracting officers. I mean, that's where you have a front-loaded part of the system and you have a back-loaded part of the system. And so you're trying to get as much information to your contracting officers pre-award to make sure that we're only truly working with those that are responsible.
I see. All right. Thank you very much.
Thank you. I'm going to follow up on the ranking member. Ms. Stiles, when we look at suspension versus debarment, in your experience, and I know Mr. Army knows this from the outside, suspension is often used for a poor performer because piling on additional contracts, by definition, only makes a matter worse. In other words, if you're growing into ineffectiveness, if you're growing in a way in which you can't handle the contracts you already have, suspension is more often looked at as, if you will, temporary versus permanent. Is that roughly what we should understand for the record?
So absolutely, and they're measures less than suspension. So there are show cause letters from agencies to understand why they would have a termination for default. I have seen them in instances where there is poor performance on one contract, where the agency has had them come into the suspension and debarment official and explain why the company should not be debarred permanently because of the poor performance issues, and we're seeing it more and more. So the agencies are becoming more active in following the information that actually is available on FAPIS, on termination for default specifically.
Well, and Mr. Amy, you mentioned BP, and I want to broach that for a moment, because in any legislation we want to make sure that we get the best value for the American taxpayer. The failure of BP to oversee a drilling rig in the Gulf versus the delivery of finished product fuel, wouldn't you agree that one of the challenges when you get into very large companies is you can have perfect performance over here, no logical reason for suspension or debarment, and you can have over here an entity that should not get access to do what they were doing again at a minimum until they prove that that bad outcome has been prevented? Would you say that bifurcating is inherently part of it? And I'm using them as a large, very separated entity. I could be using Lockheed Martin or Raytheon or any number of other entities who operate in very different areas, and it's one of the areas, I think, of concern for procurement officers.
Yes, and there are ways to get around that in the suspension debarment system. Boeing was suspended, but it was only a unit of Boeing, so the whole company was not suspended. It was only, I think, their missile division unit, and then some certain individuals that headed up that department. So there are ways to kind of massage that issue, especially for the larger contractors.
Sure.
But in the case of BP, BP had, in our Federal Contractor Misconduct Database, BP, I think, is either 1 or 2 in the number of instances of misconduct, and they had numerous instances of other environmental violations, some procurement-related, some non-procurement-related instances.
Yeah, and I'm not picking BP other than that from a legislative standpoint, and you were very kind to call it minor tweaks, but we're concerned that this kind of legislation happens once in a generation. Right. So whatever we leave off or we do wrong, you and the oversight, if you will, the Sunlight community, and the GAO and our IGs are all going to be dealing with for a generation if we miss something. So that was an area, and I think the ranking member and I would share that we're not asking for input as much for big companies. I think when we look at Raytheon's space activities in some program versus there being a vendor to Boeing in others, those are so big that it's pretty easy to go through them, and we can have an exception at some level. But it's really the person who's delivering office supplies that is a crook versus the person delivering office supplies that makes a mistake, and making sure that we divine the difference so that we're not losing valuable vendors. And I'm very concerned that we're writing thinking about big companies. I want to make sure that it works for the smallest vendor, too, both to catch them when they're wrong, but not over-punish them when it is, in fact, a benign occurrence.
Well, and that's where the flexibility is needed in the system, whether it's within your board or within the individual suspension debarment offices, to look at the facts before them, look at the record that they received from the other oversight agencies within the Federal Government, talk to the company, to make sure that you have a fair, level playing field. And I think actually with the consolidation, you may actually find that you're going to get more of that. A few years ago, I talked to a suspension debarment official, and he said, if I would have known that other agencies had entered administrative agreements with this same company, I wouldn't have been the fourth. So at that point, there wasn't a sharing information that was helpful to realize what the full record and the track record of that company was.
And Mr. Newman, the proposal Mr. Amy gave of if IGs were able to make direct referrals and that they were immediately considered, at least for suspension, figuring 74 major IGs, and as we consolidate the understanding, do you believe that that would be helpful to the process to essentially empower IGs to make findings due to their audits?
Yes, we do. We saw in our 2011 report that agencies with active programs often got referrals from the IG, so they're very important to the referral process.
Ms. Stiles, having been at OMB, there's an OMB think, which is let us manage it, we can manage it. How much should be left to Office Management Budget and others to finalize versus how much do we have to put strictly into legislation, in your opinion?
So the ISDC was created by executive order. It would probably be helpful for that to be in statute. I do think because OMB effectively manages the FAR Council and the non-procurement rules, which means the grant process as well, that they are the right place to make consistent government-wide changes that need to happen to the rules and processes and tools. That's the only place it can really happen from a consistent basis.
Do you see any conflict in essentially second-guessing the grant process and exceptions to a suspension debarment? Do you see that it can be bifurcated at OMB sufficiently that you're not sort of encouraged to get the money out there and at the same time encouraged to spend it well and at the same time being pushed for bad actors?
So the management and the budget process over there have been bifurcated for a long time, and so I think they run pretty well separately in terms of understanding their roles and responsibilities there. I do think that the procurement and the grant process need to be put together, which I know is part of your legislation. It makes no sense whatsoever to have two different processes that are absolutely inconsistent for the same suspension and debarment process.
Well, my time has expired. I will comment strictly for the record that one of the challenges that I think we face is that when you define something as a grant more broadly, not just suspension, debarment, versus procurement, you often go from a system that does a really good job of saying you have to justify the winner to a beauty contest with grants. And that's a separate problem for this committee to make sure that grants are as objective as possible rather than subjective, but that's another hearing. And I am told next we go to Ms. Kelly.
Thank you, Mr. Chair. Good morning. Mr. Newman, you have looked at a number of agencies with a variety of suspension and disbarment programs, but I'd like to talk to you about what you've learned about best practices. Your 2011 report notes that agencies with the most suspensions and disbarments have dedicated full-time staff. Should all agencies have full-time staff to manage their suspension and disbarment programs?
Not all the agencies necessarily have full-time staff, but they do have dedicated staff that are tasked with looking for and considering cases for suspension and debarment.
So even though they're not full-time, that's the only thing they focus on, you're saying?
They may have other duties, but they do spend a portion of their time doing that. But many of the agencies we looked at in 2011 did have full-time staff, but our characteristic that we thought was important to note was that it be dedicated program and staff with full management commitment.
Okay. The report also mentioned that agencies with the most suspensions and disbarments, also have detailed policies or guidance involving the suspension and disbarment process. What do you feel the key policies that lead to an active S&D program?
Well, there's many different policies and guidance out there at each agency, and they're unique to the agency, but it allows people within the agency to understand who to refer cases of contractor misconduct or serious poor performance for referral to the appropriate officials. And so those policies and procedures went beyond what's in the FAR to actually implement it, so someone at, let's say, EPA knows exactly who to refer the case to.
Okay, thank you. You indicated that agencies with the most suspensions and disbarment also have an active referral process. What are the elements of an active referral process?
Well, for example, at DOD, where we looked at 2012, we looked a little more deeply at 4 components at DOD. We found that they actively met with the IG community. They trained contracting officers and other officials that had access to contractor records to get referrals, and they coordinated with the Department of Justice.
Okay. And lastly, your statement also mentions other efforts underway to improve coordination of suspension and disbarment programs. Can you please elaborate on those?
Well, we were pleased to see that OMB had taken action to direct agencies to participate in the Interagency Suspension and Debarment Committee. That committee is only as effective as its member agencies' participation, so that's very important. And I think that's one of the key things to having a system of suspension and debarment, to having that coordination between the agencies so they can coordinate on many things, including sharing practices, deciding who should be a lead agency, and then bringing more transparency to the process of suspension and debarment.
Okay, thank you very much. I yield.
Gentleman yield.
Yes.
I was just talking to the chairman about the whole idea of when you have debarment and then you have suspension. And I was just wondering, do you have a situation where you folks are, say for example, it appears that somebody deserves a debarment, and so those who are making the decision say to themselves, well, you know, we don't want to be so harsh. And so they then end up giving them the suspension, and how that interplay. In other words, if it sounds like somebody should get a debarment, in other words, do they have a longer suspension? I mean, how do you follow me, Ms. Stiles?
Yes. So most agencies, DOD, GSA, have been dealing with this through show cause letters. So instead of suspending the company, because if you suspend the company, it becomes public, their stock prices drop, and a lot of times suspension and debarment officials have only read an article in the paper, or they don't feel like they have enough facts in a particular situation, so they have created their own process. They issue a show cause letter, which is not a suspension, and they ask the company to come in and tell them what's going on.
And now that's private. This is all private, right?
Yes, sir.
Okay. And so, and then the company comes in and they then talk about what the issue is, and then they either let them go or what?
So they oftentimes have actual filings. So it depends. The process varies by agency. Some of them may require an actual filing with the agency. Some of them may allow you just to come in and discuss the issue and make a presentation in person. Some agencies have both. At that point in time, the suspension and debarment official decides whether he wants to go ahead with an official suspension or proposed debarment process, or if he believes the company is presently responsible, and then he will usually give the company a letter stating that they are presently responsible.
And just the last thing, just wanted to talk about communications between agencies, because it sounds like, Mr. Amy, you were talking about that. How much of the communications do we have between the agencies? And then I'm finished.
Oh, my experience is there was very little until we got the FAPIS database, but even then, you know, are we getting the right and the quantity of information that we need in there for the contracting officers as well as the suspension debarment officials to make the proper rulings?
Thank you, Mr. Chairman.
Thank you. We now go to the gentleman from Tennessee, Mr. Duncan.
Thank you, Mr. Chairman. Mr. Amy, in every industry, the more it's regulated, the more it ends up in the hands of a few big giants, because the little guys just aren't able to get the contracts or the favorable regulatory rulings or various other things, or comply with all the rules and regulations and red tape. And we end up with this big government, big business duopoly. And we see that now in the Dodd-Frank law, because it was passed to get back at some of the big Wall Street banks and financial firms, and yet over 200 small banks have gone out of business. And I noticed in your testimony, you say large contractors have the financial means plus high-priced attorneys that enable them to negotiate an alternative to suspension or debarment. The possibility of delays, litigations, and reductions in competitions can mean the difference between the maximum penalty and the lesser sanction. As a result, large contractors have an unfair advantage over smaller contractors when it comes to avoiding suspension and debarment. What do you think the Congress can do to prevent or rectify this problem of too big to suspend or debar, this favoritism that's going towards the big giants?
Well, I think the regulations that we have in the FAR will work if they're utilized properly. There is a provision that allows for waivers or compelling reason determination, so at that point, even a suspended or debarred contractor can still get new business, and we saw it with Boeing during their suspension. They received multiple waivers. So if it is a large contractor and we do need them for the competition, then at that point the government can get around it, but at least they have the safety that they've been suspended, but we're going to grant them a waiver, and if so, I think that waiver should, or justification should be publicly available so that we can all see it. The too big to suspend or debar is a problem. I mean, when MCI WorldCom was suspended, their suspension was lifted just days before the next big, huge national telecommunications contract was awarded. And when I called people within the agency, they said we needed them to compete. So at that point, we have seen some trade-offs in the system. Small businesses are at a disadvantage because mainly they're operated by a small number of operators, owners, or have a small number of employees. So it is more difficult for them to take action, like in a large business where you can, let go an executive or managers or whoever it may be that was at fault. We just don't see that with the smaller or mid-sized contractors. And also, they don't have the legal resources to fight, as Ms. Stiles mentioned, of going in, receiving a show cause letter, and then going in and, doing what they need to do to protect their business. Unfortunately, they're not in the same position as a large contractor with the resources they have.
Well, I hope that we keep that in mind as this legislation progresses. But before my time runs out, I want to ask you about something else. In your testimony, you talk about the Inspector General for Afghanistan Reconstruction and how that all these companies and people that were still getting taxpayer money even though they had actively supported terrorism in Afghanistan. And you mentioned the December letter sent by a bipartisan group of senators and the January 2013 reply from Secretary McHugh, in which he said there was not enough evidence. What's the situation since then? Have you looked at those any of those to see if there was enough evidence? I mean, that sounds terrible to keep giving taxpayer money to companies and people that are actively supporting terrorism.
You're correct, and we haven't looked at it because it hasn't been publicly available. I have had some meetings with people in Segar's office, and they're still upset that the SDO within the Army wasn't acting on these. And I do think that this is where, when the Secretary of the Army responded, he said, well, we didn't have enough evidence based on the higher, the evidentiary standard for a debarment, but he didn't refer to whether there was enough evidentiary evidence that for the lower standard for a suspension. And so the fallout of that has been that the Segar has actually asked for suspension debarment authority. And that's another issue that this committee may want to consider. But should IGs, as kind of the investigator, the prosecutor, the judge, and the jury, then have that much power? But Segar and at least SIGIR, the Special Inspector General for Iraq Reconstruction, are a little different. I mean, we are spending billions of dollars very quickly in a contingency environment, and therefore I think it's worth putting on the table on whether they should have some kind of authority when they find certain evidence against contractors in those environments on whether they should have the authority to hold those contractors accountable.
Well, thank you very much. Lastly, very quickly, Mr. Newman, why are there so many persistent problems with the SAM database? Are those being corrected, do you think? Or?
Well, we've seen
a lot of complaints, apparently.
Yeah, I'm sorry. We've seen problems in the past with the database for unexcluded parties, and this continues in the SAM. We understand that there's numerous technical glitches including inability to search on DUNS number, which is a unique identifier for companies. So that's something that definitely needs to be corrected, and we hope that GSA is working towards that.
We spend fortunes on all this technology, and yet we seem to just take anything. If somebody says computer glitch, we seem to accept things that we should never accept. Thank you, Mr. Chairman.
Thank you, and perhaps we should let the NSA do it. They seem to be able to deal with big databases. Ms. Stiles, following up just on what the gentleman had asked, the proposal of special IGs dealing in foreign nations being able to essentially bypass ordinary due process and be the judge, jury, and hangman. What do you think about that from an OMB? Is that a process that you would support essentially support Congress agreeing to in the case in which you're dealing with a overseas special operation generally in relation to a war zone? And I might mention that Abraham Lincoln would have supported it.
I actually think the Army does it overseas as well. I think they have special people overseas that do it. And in that situation, and I think many of your civilian agencies would tell you the same thing, is that they know and understand the situation and their contractors better, and that they are able to assess the situation and deal with it in the more appropriate way because they're there and they're close to that contractor.
Thank you. The gentleman from California.
Thank you very much, Mr. Chairman. The Federal Acquisition Regulation requires Federal agencies to ensure that contractors have a satisfactory performance record and a satisfactory record of integrity and business ethics before they make purchases and award contracts to these individuals or companies. Does the GSA suspension and debarment database document a contractor's past performance record on prior government contracts?
There is some past performance information available, but there's information on FAPIS, rather, that includes administrative agreements and other things. But GSA does manage these databases, so I would have to defer. I could get back to you with more specifics on that.
There is a past performance information system database that's just not publicly available. So it is part of the system that they're putting together, but it is not information that's made publicly available. It's only available to contracting officers and the contractors.
Are we dealing with one system or various systems?
It's one system that was tried to be put together collectively. So it's all trying to be put into the system for award management.
So that different departments could actually know who is a good actor, bad actor, et cetera?
Yes, sir.
But there are questions about past performance information on whether it's genuine and helpful. In the past, we've heard some examples of grade inflation for past performance. In contracting officers will give the minimum grade that doesn't get them sued or involve litigation. So at that point, I think their GAO is even, it was either GAO or a recent IG report that even talked about the past performance information isn't where we really need it to be very helpful to contracting officers.
And when you're talking about the government having to be concerned with being sued, once again, as was mentioned earlier, the bigger the corporation you're dealing with, the higher likelihood that they're going to fight with lawyers, et cetera, and try to protect their name or what have you.
The larger the corporation, and also it depends on the government's reliance on those contractors. I mean, there are a lot of contractors that we're giving hundreds of millions of dollars to, and there's a few that we're giving billions of dollars to annually. And so at that point, it's very difficult to hold those contractors accountable when you need them and different agencies need them on a daily basis. Even with suspension debarment, I mean, it's, a contractor can still work on their existing contracts, but they're not permitted to get new contracts. And, there's even questions there when there's options or there's extensions of those. Should suspension debarment, the rules say it can apply and they can exercise it, but there's questions on, does that hurt government mission in the fact that you're taking someone out of the equation that was there, that you're going to have a drop-off and a learning curve to bring someone else in. So at times the system handcuffs the government.
Yeah, and there goes the experienced legislators know that when you have legislation, there's a big difference between the word can and shall. Big difference. So it's very permissible when the word can is, and then it's open to interpretation. POGO has recommended that the contractor performance and responsibility system would be improved if contracting data were made public and posted on a public website. Mr. Amy, how would making past performance information publicly available improve the government-wide suspension and debarment process?
Well, in multiple instances, I think it would be more helpful to actually the contractor community, because we do see a lot of bid protests, and bid protests slow down the system. So at that point, it would be nice for contractors if they lose a contract, that they're going to know right off the bat before debriefing anything else, here's what the past performance ratings were for this specific contractor, for this specific program, to have it publicly available. I would assume that we would see a decline, at least on past performance bid protests. Also for the public. I mean, it's very difficult in the public side to hear about contractors that break the law or violate regulations, or whether it's in a government report or in the news media, and then continually hear that they're performing well and the government keeps using them. The Army, especially in Iraq, has used multiple contractors that have had a laundry list of allegations against them, and it's very difficult, I think, public perception-wise, contractor-wise, to feel that we do have a level playing field for everyone in the system, both small businesses, mid-sized businesses, as well as the large contractors.
When it comes to resources for holding companies responsible for their actions and or their standard, whether or not they're meeting our standard, are your resources increasing or declining to enforce that?
Mine or the government's?
Our government's resources. Because this is a process. It takes men and women hours and databases, et cetera. It takes funding for us to be able to defend the government's position with these multi-billion-dollar hundreds of billions of dollars in contracts that go across the board in any given year.
Well, it's kind of been a up and down system. I mean, a few years ago, many years ago, we cut back on the size of the acquisition workforce, which is your contracting officers, which are our first line of defense. We've been cutting back on the IG community, which, there is return on the dollar for the investment that they make of their time in trying to fight waste, fraud, and abuse. But as government is trying to make ends meet, I mean, I don't see resources increasing in those areas, and in a lot of instances, they're probably going to shrink to minimal levels. So it's something that we have to be wary of.
So less resources means it's harder to actually hold the contractors accountable.
It can be, but that's where the consolidation of all these systems is trying to make it a little easier, by having kind of a one-stop shop where a contractor can go to get information on past performance, get information on present responsibility, track records, administrative agreements. We're trying to, which should be in this day and age, is we're trying to automate the process to make it a lot easier, so it's a lot less staff time, a lot less paper shuffling back and forth. But as people have mentioned, the SAM system has increased, a lot in money. It's behind, it's over budget and behind schedule, and even it's been shut down because it wasn't working efficiently. So at that point, even the systems that we're creating aren't working. And I actually think the SAM system is a step back. I mean, the EPLS worked well if you knew how to use it, and now I even struggle, and I use these systems on an everyday basis, trying to find who's excluded in the new SAM system.
Thank you, Mr. Chairman. I yield back.
Thank you. The question for the committee might be, did we debar the person who failed on the SAM system?
Right.
No, we're not going to say IBM publicly, promise you. We now recognize the gentleman from Utah, Mr. Chaffetz.
Thank you, Chairman, and I appreciate you holding this, and thank you all for being here. Mr. Newman, I want to ask you, the GAO did this great study back in 2007, April 19, 2007. It says thousands of Federal contractors abuse the Federal tax system. And right at the very beginning, right at the top, it says roughly there are $7.7 billion owed from Federal contractors that had unpaid Federal taxes. Went on to say that that was an understated number and gave some reasons why. Is there any sort of update to this? Is there a way to look at this on a more regular basis since the 2007 report?
I'm not aware of any recent work that GAO has done to update that, but I can check and get back to you for the record.
That would be real helpful because, Mr. Chairman, it says in the second sentence, specifically 27,000 DOD contractors, 33,000 civilian agency contractors, and 3,800 GSA contractors owed, and then if you tally them up, about $7.7 billion. And it would be And Mr. Amy, I think you want to add something.
If I may, and those reports were great, and this issue has even come up recently with going after government employees that haven't paid their taxes, and it recently came up with contractors that haven't paid their taxes. And that's been one of the systems that they've said, okay, then we need probably mandatory disclosure or mandatory suspension or debarment if you are a tax cheat. And so that's kind of been the knee-jerk reaction on the Hill, but it would be nice, even from my perspective, to get an update on those reports, to hold those contractors accountable in the present day.
Yes, and I would share with the panel, and as the Chairman knows, we passed out 2 bills, one that requires Federal workers, if they haven't paid their Federal taxes, they should be prohibited from getting jobs and should be relieved of their duties if they're unable to get on any sort of payment plan. And also specifically, we did one very specific to contractors. If they haven't paid their Federal taxes, they should be prohibited from getting additional Federal contracts.
And there were some issues with those reports because I think they required IRS cooperation, which isn't always easy, to be able to get access to those records. But also in the responsibility determinations, there are annual, are they annual?
Yeah, I was going to add, there's an annual certification now.
Right.
So what happened since that report is that there was added an annual certification that actually you will find in SAM. You can pull it up for any contractor that makes a certification that they don't have any delinquencies over $3,000. So that has been helpful. I think it's people have to fill it out and they have to go and look and know and realize that they have to go pay it before they can become a contractor.
Okay, let me shift gears if I could, I want to talk about the Department of Defense, where so many of these big problems are. My understanding is that DOD has set a goal of completing suspension and debarment referrals from the Inspectors General within 30 days, but the reality is these are taking close to 323 days was the last average that we saw. So here you have the Special Inspector General, Mr. Chairman, on September 18, 2012, sending us a letter saying that we have contractors that are affiliated with the Haqqani Network, the Taliban, and or Al-Qaeda. We, as a responsible group here, the Special Inspector General for Afghan Reconstruction sends this over to the Department of Defense. And says, here are the here are the problems, and yet not a one of them gets reviewed, let alone debarred along this process. So how do we solve that? Why not just give the cigar in that type of setting, given the fact that we're funding the very terrorists that are killing our men and women, instead of dealing with the bureaucratic mess that is the Department of Defense? Mr. Amy?
Well, it's a really good question. I think there's a fear factor involved there with the checks and balances in the system to make sure that the IG isn't the one making the findings and then also the one making a decision on the future viability of that company or individual.
And my understanding is, Mr. Chairman, the Department of Defense has one person dedicated to this. So we have tens of thousands of Americans serving overseas, and yet we have billions of dollars going out the door, and we have exactly one person to review this. And why we allow that person to just ignore what the cigar is able to find is pretty appalling.
Well, I hope in my best dreams that they're not ignoring the problem, but it's not an easy process. Suspension, debarment.
Yeah, but we were talking about the Army, by the way, just the Army. And this person sits in the United States of America, doesn't even sit in Afghanistan.
Well, I believe there are some suspension debarment officials within Iraq and Afghanistan.
If you can name one, if you can show me an email and point them out to us, get them back to us, because it's not happening, and it's a travesty.
I can't disagree with you more. In 323 days, it seems overly excessive. So at that point, I hope that there's a way to turn these around. And that's one of my suggestions for the Suspend Act is to get referrals. Like at that point, there is an argument over the evidence that the cigar provided to the Army SDO, but at least we should have some kind of decision on why it's taking so long, some kind of transparency in the system to report back on, are you considering them? Have you made no decision at all? Do you
Mr. Chairman, as we yield back, perhaps what we should do is give the Department of Defense an opportunity to challenge it, but if unchallenged within 30 days, then they do go into the suspension and debarment. Make the Pentagon proactively say, no, we want to keep this person and make a case for it. We just can't keep taking these chances. I appreciate the generosity of time. I yield back.
Thank the gentleman. We now go to the gentlelady from Illinois, Ms. Duckworth.
Thank you, Mr. Chairman, and thank you so much for holding this hearing today. I really applaud your efforts to bring more accountability, efficiency, and transparency to the Federal contracting process. You know, the conversation we're having today is absolutely critical for fiscal responsibility of taxpayer dollars and good government oversight efforts. I'm very much looking forward to working with you both on improving contracting practice at civilian agencies, which is the focus of today's hearing, and hopefully taking a closer look at the problems at the Department of Defense. Gentlemen, the wars in Iraq and Afghanistan have showcased some of the difficulties in managing contractors who perform government contracts overseas. So far, we've talked about debarment and the lack of debarment for folks who are here in the United States. But as my colleague, Mr. Chaffee, pointed out, we have a lot of contractors overseas who are also in need of debarment. For example, in 2007, the State Department came under criticism for its handling of the prime contractor, First Kuwaiti General Trading and Contracting Company, which was tasked with building the American Embassy in Iraq. This committee raised concerns at that time about the poor workmanship performed by this contractor, as well as its past record of corruption, which may have been purposefully overlooked. Suspension and debarment is one tool that the government has at its disposal to help ensure accountability when dealing with contractors. However, a tool like this is only effective if it's actually used. Mr. Newman, GAO's recent finding shows that there has been little use of suspension and debarment against military contractors with poor performance records and documented ethical violations, especially overseas. Are there special circumstances when we're dealing with these overseas contractors that might account for that?
Well, at the time of our review, we did find that the Army and other DoD components had good processes and procedures in place, but they do have limited staff. So they have dedicated staff, but they get thousands of referrals every year. And so that's something that I would defer to the Army as to what accounts for the time that it takes them. But it seems that they should be investigating all leads, and we found that they did do that in the cases we looked at when they had sufficient evidence that indicated there was a misconduct or some other wrongdoing.
But have they actually debarred anyone overseas?
I don't recall if we had any specific cases that involved, I think there were some that involved overseas contractors. When we looked at 75 cases, I would have to check our files to see how many of those, if any, were for overseas contractors.
I believe, excuse me, I believe there was one that I know of. I think there was a company, Agility, that has been suspended, and I think is even involved in current ongoing litigation. But you raise a good point, and it was raised by the Commission on Wartime Contracting. I think they held a hearing on it, in some of their interim reports and in their final report on the underutilization in contingency environments of the suspension debarment system, getting justifications for declinations of holding contractors accountable. And they did present in the report the unique circumstances that contingency contracting presents. And in the case of First Kuwaiti, they were the largest contractor that was building the Baghdad embassy. So it wasn't like, if you were, they could continue to work on that contract, but there would be some real questions about being able to use them in that environment where they have the logistics there, they have the people there. I mean, the one thing you do have to weigh in all of this is fairness, and due process for the contractors, but it's also fairness for the Federal Government, because you don't want to eliminate competition or place the government, at a disadvantage by ruling out contractors. And there's only a certain number of contractors that can do big picture work, and that's unfortunately the way we bundle contracts now. So.
But that's how we got to $800 million overpaid for food contracts in Afghanistan to Supreme. Ms. Amy, I mean, what do you think why do you think certain agencies will refuse to initiate sanctions against a company that flagrantly disregards the law? I mean, and I'm thinking specifically of the case of Academy Blackwater, which continued to be used as government contractors after a criminal investigation by the U.S. Attorney of the Eastern District of North Carolina found that they engage in repeated systematic violations of U.S. laws and regulations that protect national security over an extended period of time. I mean, at what point do you say, well, you're the only game in town, so we're just going to continue to work with you even though we know you're breaking national laws. And I mean, at some point, you got to stop.
You are correct. And it ends up being a question of the competition for the Federal Government, but it also ends up being a question of present responsibility. I mean, what you're looking at is this time. Like, at the time you get a referral in, you're looking at a contractor or a grantee, and you're saying, are they presently responsible? And usually what happens is, once an allegation comes out against a company, they fire people, they bring in a corporate compliance monitor, they proactively self-police and do the best that they can to mitigate any further, mitigate a suspension or debarment, because they don't want that to hurt their bottom line. So a lot of times what SDOs are looking at is only, are you currently responsible now? And sometimes it may not matter what they did a week ago or 6 months ago. So again, suspension and debarment is not a punishment, and therefore the SDOs are somewhat limited. Unfortunately, I do think that we buy too much into the promises that are given by the contractors, and I would like to see the use of suspension debarment. If we do need them again, then grant them a waiver, and let's bring them back in and let's justify it. They're suspended from future contracts, but we need them, and here's why, and let somebody justify it and go on the record, so at least then we know why contractors with poor performance or that have defrauded the government are still receiving taxpayer dollars, rather than having us all sit here and scratch our heads.
Thank you, gentlemen. Ms. Stiles.
I thank the gentlelady. Recognize myself for my 5 minutes of questioning. Ms. Stiles, you stated in your written testimony that the actual process of suspension and debarment varied widely across Federal agencies. You also mentioned that there's the lack of access and transparency not only creates an impediment for companies that are working to improve ethics and compliance programs, but also creates issues of fairness. Can you describe for us further and suggest some changes that might be made to improve this process?
Absolutely. I think what you find is you have a written system. You have the Federal Acquisition Regulation, and you have non-procurement rules. And the problem is the active suspension and debarment agencies over time have really created some flexible processes to get information and to be fair to contractors. But if you are a company that either is proposed for debarment or suspended, or you're a company, believe it or not, lots and lots of companies proactively go into suspension and debarment officials to talk about compliance and ethics issues. So if something happens at their company, if there's an article in a newspaper, if they are under investigation, the first thing they do, and the first thing we recommend, is that they go in and talk to their suspension and debarment official about how they discovered the activity, how they detected it, how they fixed it, how they remediated, what they've done to enhance their compliance programs. So there's a lot of interactions going on between the active suspension and debarment offices and contractors to recognize the fact that some bad things can happen at good companies, and you want to improve compliance programs. And you also have situations with medium-sized companies and small companies that get into trouble, didn't realize that they needed to have a compliance program, that they needed to have an ethics program, and so they actually work with these suspension and debarment officials through these unwritten practices and using the tools like administrative agreement to make the companies better contractors.
How different are the procedures between various SDO offices?
They are vastly different. It is like night and day.
Describe some, maybe an example of working with two different entities on very similar issues.
So you could work with the EPA or the Army, which has a more hearing-like process. They have a suspension and debarment official that actually acts more like a hearing officer. They have people that work within the office that present the case and that work with them. A lot of times the Inspector General is involved in presenting the case. You have agencies with significantly more informal practices. So the General Services Administration, the Small Business Administration, in many respects the Air Force or the Defense Logistics Agency, they're much more informal. They'll issue a show cause letter for you to come in. They'll ask for some written statements. So the practice is, I think the difficulty with the system right now and the way that it can be improved is by putting a lot of these unwritten policies, procedures, practices, tools into the FAR, into a place that anybody can understand that they're available, even the other civilian agencies that may not know that there's a show cause letter or that you could have an administrative agreement, so that even a medium or small company would have fair access to the system and understand what they might.
So you would say consistency would be very helpful for contractors?
Absolutely. It would be very helpful just to be able to understand the process, because you can't read the rules and understand the process right now.
Seems common sense, but let me follow up. In your written testimony, you mentioned you have confronted a number of problems for contractors under the current lead agency process. What were the problems and how should we address them?
So the main problem that we see is that there is no actual written in the FAR articulation of what a lead agency is. So one agency will take the lead for the entire Federal Government. So one agency makes a decision if a contractor or an individual will be suspended or debarred for the entire Federal Government. And as you know, many contractors work with a variety of agencies. It is hard to understand how that actually happens. Now, I have seen it in process where one agency sends an email to all the other agencies on the Interagency Suspension and Debarment Committee telling them, I'm taking lead agency. If you're interested or if you think you should take lead agency, let me know. It's not something that we as contractors have a lot of access or information to, but what's important are the companies that want to proactively go in and talk to their suspension and debarment official when there is an issue. That's exactly what you want. You want early engagement between contractors and the agencies. You can't figure out on your own which lead agency you should approach. So we've had situations where we have approached the agency where a contractor has the highest dollar value contracts. We assumed we were the right agency. We had extensive discussions and filings with the suspension and debarment official, only to have a completely different agency debar the company the next day for the same issues. So that agency didn't tell the other agencies that they were considering the suspension and debarment matter of this particular company. And so all the effort that this company went through to prove what they had done to remediate was for naught, because then they were publicly suspended.
Okay. Thank you. My time has expired. I recognize Ms. Norton.
Thank you, Mr. Chairman. I appreciate this hearing. Mr. Amy, I have a question for you based on a report from the Commission on Wartime Contracting in 2011. Now, the only experience I know personally about debarment and contracting comes from my own experience as chair of the Equal Employment Opportunity Commission, where we worked with the Office of Federal Contract Compliance. Now, lots of folks wanted debarment and suspension. It rarely happened. But actually, the OFCCP was very effective in combating discrimination because it did a lot of monitoring, and nobody wanted to lose a contract or be held up as somebody who discriminated. So it did a quite effective job. Now, I was looking for some recognizing that debarment, for example, is a kind of nuclear weapon. I was trying to think of something short of that would get people's attention. Now, I note that this Commission on Wartime Contracting from a couple of years ago recommended something that seemed to me to be very mild, and at the very least it would have occurred. They recommended that the State Department, because they were talking about State Department funds, document in writing their justification for overturning from debarment officials, the people whose job it is to evaluate this, their recommendations for suspension or debarment. Put it in writing. In writing, you might have thought that if you're going to overturn it, that would signal not only to them but to other contractors, you better watch out. It's not as easy as you think. But I understand that the State Department responded that simply putting in writing their reasons, and surely they had reasons, would have been overly burdensome. Right. So I'm flummoxed at that. Do you agree that such a requirement to put in writing while you're overturning the recommendation of those closest to the facts would be unduly burdensome?
I do not agree with that statement of the State Department. And I would like to even see it expanded further, that we see, summary data at least at a minimum, but all data from SDO's office on what it went through, kind of what was presented by either the government or by the contractors that made them make any decision, whether it's a declination or not. I think even if they are going to suspend or debar a contractor, I think there should be some kind of public display of that information, so it does put contractors on notice. I think it would actually help in the sense of it will act as a deterrent. I mean,
surely in writing to see that they'll call you out.
Right.
Particularly since this information is already available. It's not like they would have to gather it, assuming they did not make an arbitrary decision. They simply have to put down the data, as you indicate, and the reasons for their decision.
Correct.
Are you aware of why they would have considered such a requirement burden, or either of the other two witnesses aware of why they would have considered such a requirement burdensome, and would either of you consider such a requirement burdensome?
So most of the suspension and debarment agencies that I work with, do have something in writing to the record about what they found.
Sure. Sure, we don't make arbitrary decisions. So the notion of putting it out there as a possible deterrent, especially when, as you have indicated, it's difficult to depar, really amazed me. Now, in the case of the State Department, we were talking about $200 billion in contingency contracting, and about a quarter of it, $60 million, more than a quarter of it, was attributed to fraud and waste and abuse. They should have been reaching out for some way to correct this, but I suspect they were left with nothing to do except continue as they were going along. Do you see the same kind of waste in taxpayer dollars if this continues, and would you take action to see to it that this recommendation of 2 years ago from the Commission was in fact implemented?
Certainly. Unfortunately, I think we see a lot of the commissions and panels that are created, produce 100-page books and reports, and then they're not acted upon, and that is one. There are a lot of recommendations, and I know that there were some efforts last year to pass, especially in the Senate with Senator McCaskill and Senator Webb, to pass a lot of the recommendation to where it was in the Wartime Commission's final report. And unfortunately, a lot of them, some got into the Defense Authorization Bill, but some fell on deaf ears. So it's an open issue, and that's the kind of information that you hope to bring together, especially with the open process that the Suspend Act has had. And I do applaud the Chairman for the way that you've gone about, putting it out and having a discussion draft that people can comment on, because I think it's going to end up at the end of the day in a better piece of legislation, because it will add a lot of debate to the current draft bill. Where we can pull on the other experiences, the IG reports, GAO, and what other commissions and panels have recommended.
Well, Ms. Stiles said that information already exists. So, Mr. Chairman, I would expect to see that information duly available and recorded, since this is not the compilation of new information. I believe calling people out, especially if you're going to overturn what those closest to the facts have said, is the least. Otherwise, you leave the impression you're making arbitrary decisions.
Would the gentlelady yield first?
I'd be glad to, Mr. Chairman.
I agree with the gentlelady that this is an issue that this bill may be timely to send some form of a message in. Ms. Stiles, from your experience, would it be helpful if either through the letter of a new law or through, if you will, the report language, we made it clear that the harvesting, maintenance, and future reference for this kind of material would be essential to the evaluation?
Well, absolutely. I mean, I think the agencies need to keep an administrative record of why they made a decision.
Not agencies. Harvesting, collection, in other words, centralizing. And, I think back to no policeman in Detroit would fail to want to know that there was an arrest or an investigation in Cleveland, even if it didn't lead to an indictment. That's sort of the way I view it, is that information, even if you can't use it in court, is valuable to know whether you've got somebody you need to look at more thoroughly.
Absolutely. I mean, you can take a look at the EPA suspension and debarment opinions that are actually public and published, and it helps you as a practitioner, and it should help other people understand how the decisions are made and where the lines are drawn. And so to the extent that you can make information public without harming companies that the suspension and debarment official actually decided didn't do anything wrong, that's always the risk that I see.
Thank you. I thank the gentlelady. We now go to the gentlelady from California, Ms. Spear.
Mr. Chairman, thank you. You know, I'm flummoxed in some respects that this issue has been around for as long as it has, and we have really done very little to address it. A system that is basically voluntary in terms of suspension and debarment, one in which the entity that has responsibility has limited resources and an incomplete and unreliable database. And we wonder why it's not working. This is newly documented from, I believe, the General Accounting Office. Here's Boeing. This is no small company, big company. Boeing has just charged the taxpayers of this country $2,200 for a bearing sleeve that retails for $10. This is a metal tube assembly. Boeing charged the taxpayers $12,000, and the retail cost is $1,100. Now, at some point, a big company like Boeing needs more than a slap on the hand. Now, the likelihood of us debarring Boeing is pretty remote, correct? But, so as long as suspension and debarment are really not options, what's going to get the attention of a Boeing? To me, the only thing that's going to get the attention of a Boeing is slapping them with hefty fines. And I'm curious, Mr. Amy, if you have any comment on that.
Well, unfortunately, I would have to disagree. I don't think fines work.
Okay.
You know, Boeing has a lot of money in the bank, and at that point, they paid millions of dollars in fines. I think when they were suspended many years ago, that plus a personal conflict of interest that occurred with a high senior level official at the Air Force that went to work for Boeing in violation of conflict of interest standards. They were fined, and if I remember correctly, it was in the $600 million range. But since that fine has been paid, there's been multiple spare parts horror story reports out by the DODIG that has showed that they have overbilled on spare parts, on screws, nuts, bolts, and the products that you just named in the most current report. So it is possible to suspend Boeing, even if it's just a portion of Boeing. And that's what happened when it was suspended before. They suspended their missile division. They didn't just suspend the whole company, but it did prevent at least that division of Boeing, that's a very large company, from receiving new federal contracts. But then it was waived. And so
where are we?
So we are in a position where at least if you go to suspend them, it's on record. It is, as Ms. Stiles said earlier, it is kind of a public nightmare for them. It is a problem on Wall Street for a company to be suspended or debarred, and it puts everybody on notice that before I award the next multi-million-dollar contract to Boeing, I need to ask a few questions. I need to make sure that their compliance and their performance standards, as well as their level of professionalism and integrity, are at the top of the charts.
So, Mr. Chairman, I guess my question is, are some of these companies too big to suspend and debar? And I think that is the situation we're in, because in the end, even if we suspend them or debar them, in the case of Boeing, it was waived. I'm also concerned, Mr. Amy, maybe you can help me on this. John Sopko, who is the SIGAR, recently came to our Congressional Watchdog Caucus, and it was pretty astonishing. We could have him come and speak to us for a full hearing and learn a great deal. He said, and with great frustration, that the Army is refusing to look at the classified evidence that SIGAR found to support suspension and debarment. And I guess my question to you, Mr. Amy, is, do you think the Inspector General should have this authority? I mean, how else are we ever going to get some kind of accountability here?
It presents a very unique situation due to the fact of SIGAR is operating in a contingency operation. And so I may separate it from, do we want to grant all IGs the power to suspend or debar contractors? I would probably say no. But with SIGUR and SIGAR, we have had, hundreds of millions of dollars pour into Iraq and Afghanistan. The money's being spent very quickly. There's a lack of oversight over the money. We're building things that aren't being used. We're building things that are being turned over. We're funding the insurgency. So at that point, I think there needs to be, if we don't grant them the authority, suspension debarment authority, I think we need to tweak the system to be able to speed it up. I mean, waiting 323 days for the SDO to make decisions on referrals is ridiculous. There needs to be there needs to be more consistency in that system and speed in that system. The legislation may get there, and I think there is a point in the legislation that talks about this only involves civilian agencies, but other agencies may enter agreements. And so that may be something where we may want to have SIGUR, Special Inspector General for contingency operations, whatever it is, mandatorily have to enter in an agreement with a board or with an SDO to be able to get those decisions reviewed quicker because, as you mentioned, it is problematic, especially when it's overseas money that is just going out the door with very little result.
Thank you. Are you back?
I thank the gentlelady, and I think your points are good. Before you came in, we had multiple questions along this line, and I think the ranking member and I came to an understanding that at least in report language, we're going to have a finding in the bill that this needs to be addressed. Whether we address it in explicit language or more, the next time a special IG is appointed, these powers must be managed. There will be some agreed-on language. Mr. Cummings and I had come to a general understanding. We'll work out the details and would love your input. We now go to the gentleman from you got to sit in the front row when you come in early because Lacey will get ahead of you. The gentleman from Nevada rather than Missouri. Well, Lacey, I always see you when you come in. The gentleman is recognized. Thank you.
Thank you, Mr. Chairman. This is actually a very important hearing, and I want to commend you, Mr. Chairman, and the ranking member, because when you follow the money, you see where there can be efficiencies identified and implemented, and we desperately need to find efficiencies, and contracting is one of the major areas. I want to ask, the amount of contracting and grant award dollars have increased from approximately $200 billion in fiscal year 2000 to over $1 trillion in fiscal year 2012. In 2009, the GAO found 25 instances in which companies and individuals suspended or debarred for committing serious offenses were later awarded new contracts. Contracting officials either failed to check the suspension and debarment database before awarding the contract, or if they did check it, the database failed to turn up the name of the suspended or debarred entity. So if we had this huge increase in contracts and awards, did we have a corresponding increase in the workforce that's required to monitor whether or not these are eligible entities?
Well, GAO has done other work looking at the acquisition workforce and certainly has found that there have been challenges there, particularly at certain agencies, in identifying the right size and the training and skill set needed for the acquisition workforce. So that certainly is an issue.
So the POGO actually made a recommendation that the ISDC reports to Congress should include the summaries of size and spending on the suspension and debarment workforce. Why is this important?
Well, we've seen well, first off, the ISDC's first report that was due in 2009 was delayed 2 years. So at that point, we had to kind of sit and wait for it. At least they got the fiscal year 2011 report out in time. But I think there's an effort, and especially with the legislation that's on the table with the Suspend Act, is trying to make the government more effective and efficient. And currently, I don't know what the total number is of SDOs that are in the Department of Defense, that are in the civilian agencies. Earlier, there was a discussion on there were some full-time, there's some part-time, so that means they're sharing hats. Is that the best system? POGO a few years ago even found contractors. The GSA hired contractors to come in and support their suspension debarment work, doing research and analytical research into the contractors that had allegations before them. So there's even a contractor workforce that's in this community, which is a little scary, and that's one of the reasons why we've recommended that we have to figure out how much we're spending on this workforce, how many people are in this workforce, add consistency to the current system to make it run better, and then also, more than likely have to put this in the hands of government employees, because a lot of the data that's in front of a SDO office is proprietary or needs to be protected, and therefore, especially after the week we had with NSA and the ties to the Booz Allen, and the Mr. Snowden, that we do have to at some point ask some questions about who is in our workforce and what do they cost.
Okay, so definitely including that with any proposed legislation would be important, the workforce element within what we're trying to achieve here. Let me ask, there were 1,300 criminal, civil, and administrative instances of misconduct for over 170 of the Federal Government's largest contractors. Out of the information that I was able to glean, what are the largest type of offenses that we're seeing contractors making? And specifically, I want to know, there was an ad hoc hearing conducted where members heard from low-wage workers who are employed by these Federal contractors who are being paid minimum wage with no benefits, even though the contractor was required to pay, prevailing wage or Davis-Bacon wage rates and failed to do so. So is that an issue? If so, where can we find the documentation for that, and what are the other type of offenses that these contractors are making?
The information you're referring to is in the Project on Government Oversight's Federal Contractor Misconduct Database, and we collect annually the data on the top 100 government contractors. So even though it's top 100, people have moved in and out, so that's why it's 172. And you're hitting an issue. I mean, a few years ago, suspension debarment only applied for procurement, and then it was expanded and it went non-procurement. So you could have a labor violation, a tax violation, an antitrust violation, worker labor issues, consumer protections. And so that's our database includes all that. Born out of that, out of this committee, in 2008, they passed a law to create a Federal Awardee Performance and Integrity Information System. It's called FAPIS. And that system is supposed to gather information, but it was only limited to procurement. So what I would recommend is we may want to go back and look at the scope of the FAPIS legislation and see if it needs to be expanded to include the type of information you're referring to make sure that that is on the radar of a contracting officer prior to award to see what the track record is, and also to the suspension debarment officials in trying to make a determination of present responsibility. Like, you want them to have the most accurate, complete, and up-to-date report possible on the contractors that we're working with to avoid risky contractors that put government agency missions and projects in jeopardy.
Thank you, Mr. Chairman. I hope that we can be as inclusive as possible with your proposed legislation and take some of these other provisions into account as your draft is being considered by the full committee. Thank you.
Well, thank you. And the ranking member and I will be meeting in a few days to work out the final tweaks as a result of this, and we'd welcome your input for that. We now go to the always noticed gentleman from Missouri, Mr. Clay.
Thank you, Mr. Chairman, and I don't mind bringing up the rear. I'll try not to take all of the 5 minutes. No, just kidding. Mr. Newman, Chairman Issa has a draft bill that would call for a Board of Civilian Suspension and Debarment that would consolidate more than 41 civilian agency and government corporation suspension and debarment functions into one centralized board. This board would be responsible for, among other things, ensuring the excluded parties list is current, as well as employing a transparent case management system that would allow the public to be informed of all cases. How effective do you believe this board would be in improving the efficiency and transparency?
Well, given that GAO has found that there have been problems with the current process and inconsistency between agencies on the activity level of their suspension and debarment programs, GAO would welcome any changes that would make improvements to that overall process and ensure consistency and transparency. I think it's important to note that there are certain characteristics that agencies will still need to have in place in order to get the referrals to whoever is managing the suspension and debarment process, including having a very active referral process involving IGs and other officials at the agency level, and be trained on that so they know what cases should be referred for appropriate action.
But having a central clearinghouse, so to say, with timeliness being one of the major factors here, do you think that would make this process more efficient and transparent?
Well, it certainly would build on some of the existing responsibilities of the current voluntary system under the Interagency Suspension and Debarment System, Committee, rather. That committee has the, I guess, charge to monitor and oversee the government-wide system, but as we noted, it's been ineffective in the past, and while there's been some improvements made, I think we still want to see some more improvement there in terms of its overall.
And how likely is it that having a single point of authority for maintenance of the excluded parties database would resolve the accuracy problems that it has had over the years?
Do you mean accuracy of the database?
Yes.
The problems of the database, I think, are longstanding. So there needs to be some look at how to improve that particular database. GAO has noted that as far back as 2005 and again in 2009. And even when we did recent work, there's still problems with the database. So I think that any efforts to take a look at the problems and have someone look at and take steps to improve it would be welcome.
Okay. Well, I thank you for your responses, and Mr. Chairman, that is all I have, and I yield back.
Well, I thank the gentleman. I'll just follow up with a quick question round that came from the earlier questions. Ms. Stiles, the process which is undocumented of show cause, our legislation currently does not formalize that nor address the reality that it is and likely will continue to be done unless we either formalize it or prohibit it. Would you suggest that as we're preparing a final bill that we do just that, either formalize it or prohibit it?
I think it should be formalized, absolutely. It is just it's a very good process in situations where an SDO wants more information. They just don't always have the facts. They want to make sure they're dealing with an ethical contractor, but they don't want to suspend them unnecessarily.
Mr. Newman?
Yes, we saw that at the Department of Defense use those very effectively to get more information, in some cases to either get the contractor to improve its ethics programs, or in other cases to get enough evidence to do a suspension or debarment. So those were very effective tools that they used.
Mr. Ramey?
And I believe the SDOs believe it is as well, because the ISDC has been reporting it on how many administrative agreements or how many settlements that they've entered into, so non-prosecution agreements, different things that are, help them, gather information about contractors. So I think the community finds it to be an important tool as well.
So getting a 3-for-3 that we should formalize it, let me just ask one question. Is this an appropriate place to tie in a specific, if you will, right of IGs to, at a minimum, create a mandated show cause? In other words, less than a direct authority to suspend or debar, the idea that IG's findings in audits and other work would automatically empower a show cause so that they would have a direct part of this. Their investigation would link directly to this process. Ms. Stiles?
I think in most of the effective agencies they already do, so they refer them and it automatically causes the show cause process to start. So it actually, I think, would be putting into statute a process that already exists.
And you had earlier said that the best part of our bill is that we take an executive order and put it in statute.
That's correct.
Okay. Well, unless I have any further thoughts from any of the three of you, I want to thank you for your generosity of time and for helping us in what is likely to be a very shortly put forward piece of legislation. We stand adjourned.